Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. Today, we're talking about the fourth question in our series, which is holding interest in property. In other videos, we've discussed what deeds are and what land records are. In this video, we're talking about why recording deeds in land records is advantageous to property owners, and we do that through the lens of the Recording Acts. Recording acts are adopted in every state in the country. These acts are meant to resolve disputes in how property owners with competing claims over the same piece of land come to prove that they own that land. There are three types of recording acts: race, notice, and race notice. All deal with what happens if there is a prior unrecorded interest in land. So remember those words, prior unrecorded interests. There are not so many race jurisdictions, but since this is perhaps the simplest, let's consider it first. The rule in race jurisdictions is that the purchaser who records has priority over all prior unrecorded interests, whether with or without notice. The advantage of this rule is certainty. You don't need proof as to whether someone had notice. On the other hand, it may be hard to tell fraudulent from non-fraudulent recordings. In other words, as we said in other videos, the recording system is not always perfect. About 23 states are notice jurisdictions. The rule in these jurisdictions is that a bona fide purchaser without notice, actual, constructive, or inquiry notice, that is, takes priority over all prior unrecorded interests, whether or not the purchaser records. Actual notice means having knowledge of a fact. Constructive notice means notice after a relevant search of documents. Inquiry notice means a reasonable person should have known to inquire further to seek the answer. In notice jurisdictions, the advantage is that it lets people who search for title find nothing. It lets those people off the hook. On the other hand, it does not encourage people to record. Finally, about 25 states have adopted race notice rules. Okay, so here the rule is that a good faith purchaser without notice takes priority over all prior unrecorded interests, provided that the purchaser records before the prior unrecorded interest holders do. In other words, someone must record to be protected from subsequent purchasers without notice. Both race recording and notice are material to the determination of priority. The advantage of a race notice system is that it protects subsequent grantees, and it also has a strong incentive for recording. On the other hand, it does hurt people who aren't knowledgeable enough about the recording system to protect their rights through recordation. So each of these three different types of recording acts has advantages and disadvantages. Working through specific examples and considering how they might be resolved through each of the three types of recording acts we have discussed today will provide you an excellent window in understanding the consequences and distinctions between each of them. So with that, I will leave it there. I'll look forward to connecting with you on Twitter or through my mailing list and my website, and I will hope to see you soon.